everybody, welcome back to the second part of our look at Waldron's A Right-Based Critique of Constitutional Rights. So a very, very brief recap in the first part of this video lecture series. We took a look at the first 6 sections of Waldron's piece here, and what were we looking at there? Well, in very broad terms, I'm not going to go back and talk about absolutely everything we were looking at, but just in very broad terms, what was Waldron doing? Well, just taking the title here, what he's doing is trying to criticize enshrining certain rights in some form of written constitution. And this is really an issue that was in the United Kingdom in the 1980s, early 1990s. They're seriously considering adopting some form of written Bill of Rights. Canada has the Canadian Charter of Rights and Freedoms, the first part of our Constitution. As part of the American Constitution, there's a Bill of Rights in there. And these are written documents that enshrine certain rights of individuals into a very basic level that, within the legal structure of the country. And what that does is really prevent the legislature, so Parliament in Canada or Congress, right, Congress and Senate in the United States, from being able to pass laws that override or change what those rights are. Now, Waldron is arguing against that from a rights-based perspective. And so we saw this in the first few sections. He was talking about right-based moral theories, how you can go from thinking about having a moral right to the question about whether or not you ought to have, morally speaking, ought you to have a legal right to everything you have a moral right to. And he says, that's not clear. The law should be such that everybody gets what they have a moral right to. Even that, I raised a few little doubts about. We don't think that the law needs to be that nobody can tell a little white lie or something, or you're liable to a fine or something like that. But presumably, if you have a moral right to get something, if that moral right is of the correct sort, then the law ought to be such that you aren't done wrong by the law. You get what it is that you deserve, whether or not we say you really have a legal right to it or not. So in section 3, he was thinking about these questions of how do you transition from having a moral right to a legal right. In section 4, he then was talking about legal rights versus constitutional rights. So a constitutional right is a kind of legal right. It's kind of like a super legal right. Not only is it a right like other rights people have, but it's entrenched in the sense that it's put in so deeply within the legal system, it's much harder to change than anything else in the legal system. So normal rights, ones that aren't constitutional, are created really, they can be created to some extent through acts of the judiciary, but largely speaking are created through acts of the legislature. So Parliament, Congress, right, where you get the representatives of the people coming together, proposing legislation, proposing what the law should be, and then voting on whether or not it should be that. And of course, as there are elections and those representatives change because what people want, what they desire, changes over time, then what the actual legislation is will be amended, some things will be struck down, new pieces are introduced, and that is going to change what the law is. So having rights, at least some rights, act as constitutional rights, acts as a kind of block on that. It's a way of slowing down or limiting what can be done there. Now, in section 5, Waldron drew some comparisons with philosophy, just the activity of doing philosophy, that just like in the public sphere, right, just like in normal thinking about society, if we take philosophers and the philosophy community as a kind of microcosm, what do you have? Well, a bunch of people who think that they're right. And I don't think I've met anybody yet who doesn't think they're right, even if what they think is that they're not usually very right about something. So we all think we're right. We think our beliefs are true. That's why we hold them. But we don't agree with each other. So it seems to follow we probably can't all be right. And by talking to each other, engaging in other ideas, having other people thoughtfully and ideally respectfully pointing out the problems in our own thoughts, proposing alternatives that we can engage with, this is a way of engaging with each other and letting our own thinking change over time. Right? And so just taking philosophers as a small community, what we have there are people who take a lot of time and great care, trying to think through certain issues very clearly. Of course, they all think they're correct and they've got the right answers, and then they engage with each other and realize that there are actually shortcomings and objections and problems and areas where probably revision is needed and so on. But collectively, hopefully, we're getting better. Right? We're getting closer to the truth by going through this process. Same thing in the public sphere. Everybody thinks they're right, but by talking to each other, engaging with each other, thinking about these issues, realizing where our blind spots and shortcomings are, seeing good objections and revising our views in light of them, slowly over time, society is getting better, or at least that's the hope. Now, section 6, and this is the one we left off on, given that we have disagreement in philosophy, the philosophy community, as well as society at large, well, we need to have some mechanisms for actually settling disagreements, at least in the community at large. Now, philosophers, at least to some extent, get to happily go on arguing with each other until they hit, their limits, right? They just argue forever, which is what we are certainly trying to do. 2,500 years going strong, and we're still arguing. Now, when it comes to actually looking at a real society, just take Canada, what you have is disagreement amongst people in the population, but we need to make a decision, right? What should this year's federal budget look like? People have very different views on that, but a decision needs to be made, right? We can't, like philosophers, just go on arguing for the next 2,500 years. Yeah, what should the 2020 federal budget in Canada really be? Wow, maybe it should be this. Oh, well, what if we carry the two? Well, what if we change this little thing? Wow, should we fund this at all? Well, I don't know, right? As fun as that would be, well, maybe, to some of you, a real decision needs to be made. We need some way of figuring that out. Should there be a law against, I don't know, vaping and driving? Why not? Should there be? Part of me thinks probably not, right? But then again, we have laws against distracted driving. And so there's a question there. How distracting is it to vape? Is it more distracting than smoking? Should there be a law against smoking and driving, right? If we have a law against using your cell phone and driving, except if you're using it for emergencies, should there also be a law that says you can't smoke and drive? Well, maybe, maybe not. And the whole point of me saying maybe, maybe not is I can see some reasons on either side of that, right? I've got an answer in mind, but I'm not convinced I'm absolutely correct. So these are the sorts of issues that we need to figure out, right? Either we have a law against it or we don't. Either it's legal or it's not. Either police will pull you over and fine you or whatever, or they won't. We need to settle those questions. We need some way of doing that. And that's precisely where authority comes in. And so what we left off on there was really Waldron saying, so we need some sort of procedure, right? We need some theory of authority to complement our theory of rights. And ultimately, one role that authority is going to play is going to be settling disagreements. And of course, we have a big parallel here with the RAS piece that we looked at earlier in the term. So at least one role of authority is going to be in settling disagreements when people have them. And so that opens the door to the possibility that you can have a legitimate decision-making procedure, right? Some sort of authority, and we say, okay, and this is how the authority is going to settle our disagreement. You can then have a disagreement settled in the right way, that is, the authority follows all the correct steps and so on, but assuming we think there are actually correct answers about rights, correct answers about moral questions, questions about justice and so on, you might have the situation where an authority, a legitimate authority, follows the steps it should, and so comes to the procedurally correct decision, but actually makes the wrong decision, right? They decide, people really don't have a, right to privacy on social media, say. Let's say, in truth, people really do have such a right, or they should have such a right. But our legitimate authority has decided that they don't have such a right. And so we're in this position where it almost seems paradoxical, where we have the decision that was made the right way, so it's the right decision in one way to understand it, but it's the wrong decision in terms of it came up with the wrong answer, right? So it seems like there's a little bit of a tension there. Now, of course, Waldron says that's not really too much of a tension. This sort of thing can happen. And so I'm not going to revisit exactly what he says there. Go back, take a look at section 6 of the previous video, but that really gets us up to where we were. And so we'll just pick up there get into section 7, I realize I've made my little picture too big. Even now it's too big. Hopefully it's not going to be an issue. I'll stick myself down there, I guess. So into section 7. Now we've had a little bit of a talk of the nature of authority and the fact that we have actual disagreements. Here in 7, Waldron comes back to a bit of an analogy between public discourse and the practice of doing philosophy, academic philosophy in an academic context like this. And he says that there's actually a useful parallel to be drawn here between seminar room discourse, right? What we do in the classroom when we're sitting around thinking about these issues and talking about them. There are similarities between that and public discourse, when we're out in the public domain, talking to each other, talking to our fellow citizens about issues of rights and what people should be allowed to do or not allowed to do and so on, what the limits on government ought to be. Now, in both places, both in the seminar room and out in public, in the domain of public discourse, you've got something similar going on. You've got real people doing hard thinking about complicated issues. Or at least that's what they should be doing. And there's I'll sort of stick this in just as a little note here. A persistent theme through this piece is Waldron drawing attention to the kind of respect that we should have for our fellow citizens and their rational capacities. Part of that is really just in the underpinnings of democracy, because if you don't think average, normal citizens are capable of rationally engaging with complex issues like this, then you might have certain worries about the very foundations of democracy, right? One way to view democracy is that it's really the best system precisely because rational agents like us, humans, are able to govern themselves by stepping outside of their immediate desires and their narrow self-interest and rationally consider large, complicated issues and what's really best for the community and how to balance individual and community rights and interests and so on. Now, of course, if you don't hold that sort of view, you might still say democracy is the best system yet, in part because it's the least worst system. It's the least likely to be exploited by small groups of people and take advantage of the majority of people. So you can justify democracy in that sort of way. That's not Waldron's favorite approach, though. He really thinks we ought to have this sort of respect for fellow citizens. If you are skeptical about that, about whether or not typical citizens within a democracy are willing or able to really think hard about complex issues in the way that they ought to, rather than just have gut reactions, sort of instinctual reactions, or think just in terms of narrow self-interest and not adequately balance their own interests versus the interests of the community around them, you might have some reason to disagree with Waldron in a very broad sort of way. And I'll leave it up to you to think about how, in the specifics, that would affect Waldron's argument, right? If that sort of assumption he has is called into question, what's that going to mean for it? Something very interesting to think about. Potentially good for, say, an essay if you had to write on this. So just coming back to Waldron, stepping away from my own sort of suggestion of how to think about Waldron and how to potentially engage with them. Both in public discourse in the seminar room, you have real people thinking hard about complicated issues. Now, academic discourse, he says, is really a kind of idealized public discourse, right? It's just sort of kind of idealized discourse in general. Academics are given the privilege to have more time and energy than the typical average citizen to think about particular tough matters as clearly and thoroughly as possible. So in particular, if we just think about, say, legal and political theorists, those people are professionally engaging with thinking about these complicated issues. So, just assuming that when people spend more time and energy on some kind of task, they get better at it, then presumably the people who are doing this professionally, right, as academics, would have the most sophisticated reasoning on these sorts of subjects. Now, just as a matter of fact, theorists like that don't all agree with each other, so you get a plurality of views, you get disagreement, but presumably in the sort of division of labor in society, they are the people who are best thinking through some particular issue, right? And look, we can flip that around if you sort of roll your eyes at that and say, oh yeah, sure. Look, as an academic, I don't doubt that people who say professionally do taxes know the most in general about doing taxes, or that people who farm professionally know the most about actually farming, or that the people who fill in, work on vehicles, they're mechanics, know the most about how vehicles function, how to actually take them apart, put them back together and fix them up and all those sorts of things. So it's really just this very basic point that when people do something professionally, as a group, it's not to say that every single member of every single profession is the best at what they do, but as a group that does something professionally is the best amongst people at doing it, just generally speaking. So academic discourse is this kind of idealized discourse. The public discourse will resemble to some degree, but of course it's going to be messier, it's going to be rougher around the edges, there are going to be issues that aren't thought through quite as clearly and so on. But Waldron doesn't think this is too much of a problem, because in academic discourse, particularly political philosophy, jurisprudence, legal philosophy, these sorts of theoretical matters that have this direct application to real people and their lives. Ultimately, this kind of discourse should be explainable and justifiable to our fellow citizens. And this is really drawing on the Enlightenment ideal that we are, as humans, all reasonable, rational creatures. We do have the power to think about these issues and actually think about them in a clear way. We don't need to have other people think for us, We are capable of doing it. Now, there might seem to be a little bit of tension there in what I was just saying, that people who do something professionally, say, think about political issues, are going to be the best at it. But there's a difference between saying that people who do that professionally are going to be the best at it. There's a difference between that and saying it's only the people who do it professionally, or only the people of, say, a certain class of society or with a certain sort of education, or whatever the conditions are able to think about it rationally at all. There's a big difference there. So academic discourse is really this way of trying to sharpen, clarify, think through more thoroughly the sorts of reasons that are already being exchanged in the public sphere. Now, academic discourse has this sort of privilege. It gets this extra time and energy to be able to do this sort of thing. So in one way, it's certainly doing it better, Waldron thinks. But there's a kind of trade-off here, which is that in public discourse, real decisions need to be made. This is just going back, picking up on exactly what I was saying earlier. Philosophers love to argue and in some sense not have to worry about the practical consequences of actually making a decision. Now, of course, that itself is a little bit misleading. We have to make practical decisions. There's a writing deadline. You actually have to write something. You've got to settle on a question. If you just think about things forever and never have any answers you're willing to propose and actually engage with other people, nothing much is going to happen, That's not going to be very interesting. So academic discourse is idealized in a certain sort of way. It should be able to interface with public discourse. That is, what's going on in academic discourse should not be wholly divorced from public discourse and public reasoning on these sorts of matters, particularly when it's about these sorts of public issues. And so ultimately, there is this kind of function that academic discourse can play, It can help actually advance debates in the public. There can be a sort of filter down effect. But ultimately, it's in the domain of public discourse within a democracy that real decisions need to be made, So we go from the ideal, from the theory down into the practice, actually having to make a nitty-gritty decision. Okay, so this takes us into section 8, the right to participate. Well, I got to move my little thing a little. So this is a theme that Waldron is going to keep up with really for the rest of the piece, namely that there is something important and interesting in a democracy from the right to participate in that public discourse and decision-making process itself. So as he puts it, our respect for the political thinking of ordinary citizens comes not only from, from the similarities between public and academic discourse, but also as a matter of our democratic principles. Now I'm going to go ahead and stop this for a second and fix that error I see. There we go, fixed. Excellent. Okay. Well, I did a bad thing. Good. All right. So, this respect we have for the political thinking of ordinary citizens comes not only from the similarities between public and academic discourse, but also as a matter of our democratic principles. What does he mean there? Well, I was largely already saying this, so I'm not going to belabor it too much. But really, if you go back into Enlightenment thinking, you look at Kant, you look at Rousseau, you look at a lot of other theorists during this time. He names Kant and Rousseau as two that are particularly influential here. Democracy is really founded on this view of people as rational choosers in some sense, right? That ordinary citizens, not just some elite, whether it be educated or by class or birthright or whatever it might be, or money, but that all people, all rational agents within a democracy, I'll say adult humans, or however exactly we want to determine who counts, that these people are autonomous, they're able to govern themselves by thinking in terms of rules and what to do, they're bearers of dignity and rights, they're moral agents, there are certain things that they ought to have, right? They get certain rights to do things, to be free from certain things, and really that these sorts of individuals are capable of self-government, coming together, exchanging reasons, thinking about what's really best for the community and themselves within it, and be able to make good decisions on that basis. Now, as part of all of this right to political participation comes as part of this package. Part of what it is to be a rational creature like us, arguably, right? So there are different ways of trying to justify this right to political participation. The one way is really by appealing to our telos, what we're like, what sorts of creatures we are, these rational creatures able to make decisions to govern ourselves, so that in fact, really part of what it is to be a being like us is to take part in that sort of process, that kind of political process, to be excluded from it, by an external exclusion, not just by your own choice, right? That would be exercising your autonomy in a certain kind of way. But to have someone or some other group say, you're not allowed to participate in this. You're not allowed to participate in the collective decision-making we're engaged in about what we collectively want to do or how we want to govern ourselves. That there's something wrong about that, that somehow violates our right because it goes against our nature. So that's one way of trying to justify a right to political participation. Another, perhaps slightly more cynical way, is just like I was saying in terms of trying to justify why democracy is a better system of government than another system. You can appeal to a sort of more cynical or pessimistic view that really democracy is the system of government in which it's least likely a small group of people is going to exploit some large group of people. Right? So you could appeal to simply the possibility of participating in the political process as a way of protecting yourself, right? By getting out there and voting, you can make sure to ward off the most abusive sorts of government that there might be. So Waldron thinks there's something very important about this. He absolutely thinks we do have a right to participate. We can try to justify it in different sorts of ways. He just gives these two ways as a kind of example. His point here isn't to make the argument that we have this right, rather on the assumption we have the right, which I think most democratic theorists are going to think we have. In fact, I think it's an uphill struggle to argue you really don't have a right to participate in the political process for most modern rights-based theories. So he's just assuming this, right? People really have this right to participate. And so our respect for the political thinking of ordinary citizens, coming back to the main point, really has two sources. One is this basis of democratic principles and the sorts of rights we think autonomous agents like us have. The other one is from the parallel to academic discourse, right? Public discourse is really like academic discourse. Academic discourse is just sort of more idealized. There's more time and energy that can go into it. So of course it's more consistent and thought out and it's more complex and so on. But that doesn't mean it's really separate from public discourse. It's just, in some sense, a more advanced version of it. drawing on the sorts of reasons that are already available in public discourse and just trying to help show where that reasoning ultimately gets us. So one last point, and this in some sense rides on that self-protection view, but not quite, it's a little bit different. Widespread political participation, having the majority of the citizens in a political community actually take part in the governance of that community, at least indirectly, say through elections, acts as a kind of corrective on myopic or narrow views, right? Like nearsighted views. So really what Waldron has in mind here is precisely the link between public and academic discourse again, and that widespread political participation, part of what that's warding off is having some small group of elites, whoever they might be, right? Academics, maybe judges, politicians, nobles, merchants. Okay, merchants is a kind of old word, business people, whatever it might be. From looking at matters through their own sort of narrow lens and interpreting everything that way, and instead, by having widespread political participation, what you get is this kind of general corrective. You get sort of all of those plurality of views in a society coming together, engaging with each other. And so what you do is strike a kind of balance, right? And ultimately, this is really the idea. A democracy that's functioning well is precisely going to try to strike that balance, right? Try to find where we can cooperate, where can we settle, right? Of course we all want it our own way. Of course we all think we're right. Those are just common features of humans. Right? If we want to actually get along with each other and not, I mean this quite literally, fight each other, kill each other, right? Hold each other as slaves and so on. If we actually want to live amongst people we disagree with, yet be able to do that peacefully and all be able to lead the best possible lives we can, we need some way of coming together and some kind of procedure for settling those disagreements and allowing us to continue participating in those disagreements without breaking down these structures and just resorting to violence or what have you. Okay, so this is really this extra step in terms of thinking with rights and engagement with people at large, thinking about political processes. Now, springboarding from that, there's a proposal that Waldron considers. And the proposal is really this. Look, given how important participatory rights are, our rights to engage and participate in the political process, maybe, minimally, those sorts of rights should be entrenched in a constitution. Right? This would help ward off a democracy, in some sense, voting itself out of existence, which is possible. Right? If you have a democracy and there are no limitations on it at all, it's a sort of majority, whatever the majority says goes, you can have a situation where the majority gets together and votes in a dictator. There's nothing against it. Now, of course, the dictator could come in, so the democracy could vote, Carl's going to be dictator for life, and we're not going to vote again until he's dead, or something like that. Or Carl will be dictator for life, and he gets to decide what's going to happen, when he dies, or, say, when he retires, right? If all the power gets transferred to me, then ultimately it's up to me to decide what procedures are going to be going forward in terms of who can participate in the political process. Now, that's possible if you don't have any restrictions at all. So this idea that he's dealing with here is just the idea of, what about sticking only the participatory rights, entrenching them in a constitution, some kind of written constitution, precisely so that citizens in a democracy can't actually lose their power, right? They can't give up on their own power and just, oh, this is too tough, let's all stop voting and we'll just sort of settle on some other procedure, right? Now, there is a worry here that, in fact, failing to entrench these rights in this kind of way threatens a democracy, precisely because then the democracy is, in some sense, open to not being a democracy anymore. But Waldron answers to this question, right? Perhaps minimally the participatory right should be entrenched. He says no, right? And for the reasons he's already been articulating in this piece, namely that entrenching those rights in some kind of written constitution, just like entrenching any rights, puts them in some sense beyond revision. Or at least it makes them much harder to revise than they would be if they were just normal pieces of, that it makes them harder to revise them if they're put in the Constitution than it would be to revise them if they were just rights granted by a normal piece of legislation or whatever the usual processes were. Right? So there's the one reason not to entrench them is precisely that it puts them beyond revision. It takes the power away from the people to actually change their mind about how these things should work and what those sorts of rights should look like. And there is this worry, right? Who says we already have these rights right? Maybe I should have used the word correct there. Who is to say we already have them correct? Them being the participatory rights. Waldron says if we take a look at history, that itself suggests we should be very modest. It is not that long ago. If you take a long view of human history, not even that long of a view, really, it has been pretty recently that in even what we might consider the most advanced democracies, or I hesitate using that sort of language just because trying to measure those sorts of comparisons is notoriously difficult. But even if you take what you consider to be pretty stable democracies, old democracies, right, progressive democracies, however you want to frame it, the right to vote for all sorts of groups of people really only in the 19th and 20th centuries have broad voting rights been granted. So, and I'm talking about having a voting franchise that extends beyond just a limited class of people who say own property or a certain amount of property, expanding the franchise to include women, right, people of color, you name it. In Canada, Aboriginal people did not have the right to vote for a considerable amount of time. I know I keep stumbling here. I'm just trying to think off the top of my head. I'll be honest, I just paused to go look it up. I was thinking it was somewhere in the 20th century, mid-20th century. If my very quick internet search is correct, Aboriginal people in Canada didn't have a right to vote in federal elections until 1960, unless they renounced their status as registered Indians. So these questions about who gets to vote, right? Who qualifies? Even just questions like what age should be the age at which you get a vote? 18, 21, 16, 15, 25? What about 50, right? What should these arrangements be like? Now, if we look at history, it suggests quite a bit of disagreement and hopefully what we could call progress in these things, but there are still all sorts of outstanding contemporary issues concerning what these sorts of participatory rights look like and what sorts of allowances and restrictions come with them. So look, there are issues concerning constituency boundaries, right? Questions about gerrymandering, about how large constituencies are allowed to be, right? Does geography matter? Is it population size? Is it some calculation that computes those two values together? Questions about how do you represent people? Right? Should we have proportional representation? Just here in Canada, just in the last, 5 years, this was an issue. When the federal government, right, we had a recent federal election that returned a minority liberal government. Before, and they came in as a majority government, they said they were going to reform how the elections worked and get rid of at least look into, I think they had promised they were going to get rid of the first past the post system, and then ultimately backtracked and decided not to do that. So there are different ways of interpreting what the votes tell us, how that puts together parties in institutions. So if you look at Canada and the United States, if you have a certain jurisdiction, say Lethbridge or something, and that's a voting district, it forms a constituency. Whoever gets the most votes wins that district. They send a representative to whatever the relevant legislature is, right? Whether they won by 1 vote or 100,000, a win's a win. And then it's the number of wins, you add that up and that's how many seats you have. Other democracies, particularly if you look at Europe, you get some sort of proportional representation where if a party got 23% of the national vote, you get 23% or something like that within the House, within the legislature. Now, and then how do you figure out who takes the seats, right? These are real practical questions. And these are all questions about what does it mean for people to have a right to participate? What does that translate into? How often will there be elections? How can parties be funded? Are there funding caps? Are there limits on election time? All sorts of important and interesting issues that surround these questions of participatory rights remain outstanding. And so Waldron's point here is it might seem like a good idea to try to entrench those rights within a constitution, some kind of written document, and put them in some sense beyond the reach of the easy revision of the people. Says that might sound nice because of the worries of, say, slipping into dictatorship or something. But you still have these trade-offs, right? By doing this, you are putting those beyond revision, which itself is, or making it harder to revise them, at least, which itself is undemocratic in some sense. We're going to come back to that worry. That's really what Waldron's going to close off with here in section 10 and 11. And it's to have a kind of hubris to think you've already gotten things right, that we have all these very complicated questions that deserve serious thinking. There are competing good theories about them, competing good answers, right, both in academic and public discourse. And to take some set of answers and stick them in a written document and say, ah, there we go, we got it right, is really to, in some sense, overestimate your own abilities and to mistrust the people around you, right, your fellow citizens, as well as future generations of citizens. So he thinks this proceduralist gambit, trying to just minimally enshrine participatory rights in a constitution itself, is going to fail. Right? It's not really going to work for us. So just carrying on in this a little bit, making it just a little bit more complex. Ultimately, in a democracy, Waldron says, everything is really up for debate, including what decision-making procedures we use to debate and actually make decisions. Right? Judicial review is one decision-making procedure. Having a written constitution of some sort that outlines different rights for everybody, and then having judges look over pieces of new legislation, compare that to the Constitution, and decide whether or not the legislation is going to work the way the legislature intended. Right? That's one kind of process. That's one way to go about things. Just using the usual legislative processes is another. Right? Just letting the representatives of the people in a democracy come together, debate issues, and vote on them in a way that presumably reflects the will of the people, right? Whatever exactly that is, but something like majority sentiment. That's another decision-making procedure. And for all its flaws, it's a pretty good one. Right? Now, there's kind of a meta worry here that we have to use a decision-making procedure to solve disputes, make decisions about decision-making procedures, right? To have an argument, right? You can have an argument about how to have an argument. But to have an argument about how to have an argument, you have to have some set of rules or guidelines about what it is to have an argument at all. Right? Now, that's worrying in some sense when we hit these sort of high level or foundational, whichever way you like to go metaphorically, up or down, right? Whether it's the highest or the lowest. Having disagreements on these sorts of really important levels, they're always there, right? Particularly when we're being philosophers. Having these sorts of serious worries, it's always around. It's a perennial concern. And so the problem's really no worse in this case than it is in any others, Waldron says. Like, yeah, you can raise the specter and say, well, look, we have to use decision-making procedures to make decisions about decision-making procedures. So doesn't that mean we're ultimately going to sort of load the dice? We're going to favor one way or the other by choosing a decision-making procedure we're going to use to make decisions about which decision-making procedure to use in the future, right? Use the legislature to decide in the future whether or not to use the legislature or something. He says, sure, that's a problem. But it's no worse of a problem here than it is anywhere else, right? And in fact, you can use a decision-making procedure to change which decision-making procedure you use in the future, right? You can use a legislative process to decide to start using judicial review, right? Or judicial review can actually sort of nullify itself, giving way to more direct legislative processes, right? As a matter of fact, these things happen, particularly if you have a constitutional arrangement that allows for change, right? It's somehow built right into it. It says, oh, well, you can actually change how this works. Here's how you have to go about doing that, some sort of procedure for it. But there is some kind of procedure to change even how the procedure itself works. Now, lastly, in practice, this kind of high-level sort of theoretical worry about circularity, or in some sense begging the question by using one decision-making procedure to make decisions about which decision-making procedures to use. In practice, it's really hard to tease apart debates on procedure from debates on substantive matters, right? So one very good example, the recent impeachment trial in the United States, which of course ran through, had to run through Congress, right? House of Representatives, went up to the Senate. The Senate really acts as the judiciary in that case. And there were some debates going on in public discourse, right, in the news, the president and members of the Senate and the House and so on making different claims. And there was a lot of talk about procedure, about how the procedure was supposed to work and whether things were working the way they should, and if this procedure was just or correct or legal or what have you. Now, of course, if you're like me, you were probably looking on those sorts of debates with sort of a mixture of interest and resignation, realizing that given the, in some sense, minimal actual written rules for how the impeachment process works in the United States, really what was absolutely clear is that the Senate acts as the court, right? Senators effectively act as jurors, judges or jurors, you can sort of, however you want to interpret that. But in some way, and there had to be a certain vote, right? The vote had to come out a certain kind of way to have a conviction rather than anything else. But all the other matters of procedure were in some sense up in the air. So of course, there was a lot of wrangling talking about whether or not the procedure was right, which seemed to be motivated by the matter of substance, that is, whether or not the individuals thought Trump ought to be convicted and removed from office or not, right? And so it became, for the most part, I think, sort of pathetically predictable which sort of people would be making which sorts of claims about whether or not the procedure was being followed correctly. Namely, if the procedure that was being followed seemed to work against Trump, anybody who favored Trump staying in office would say there's something wrong with the procedure. On the flip side, anybody who thought Trump should be removed and the procedure looked like it was working towards removal would say that the procedure was working just fine. And if you flip it around, anybody who thought Trump should be removed and the procedure looked like it was going to keep him there, say by the majority vote or something, would say there's a problem with the procedure. And conversely, anybody who thought he should stay in office, the procedure was going to produce that result, would then say that the procedure was just fine, right? What does this all amount to? When we have a debate, some kind of public debate, we've got a disagreement that we need to solve, and it's on some kind of important issue, there's the question of how do we go about making the decision, and what's the decision going to be? What's the right decision? Note, this is exactly what Waldron was talking about in the first part when he's talking about disagreement, authority, and that if we think that there really are right answers for questions, we can have a situation where a legitimate authority makes a decision by following a certain kind of procedure and might actually make the wrong decision. But precisely because we need some kind of decision-making process or set of decision-making procedures to resolve these sorts of disagreements for practical purposes, that's just the situation we're stuck with, right? We're going to disagree on what the right answer is. We might even disagree on what the right procedure is for settling our disagreement. But there's no getting out of it, right? There's nothing else to appeal to. It's just us, right? It's us here arguing with each other, trying to figure out what to do. The world doesn't solve these issues for us. There's no view from nowhere or text you can grab that just says, oh, here's just the objectively correct answer that everybody's going to agree on. We just don't get that. It would be lovely, but it's just unrealistic. It's just not our situation. So in practice, these sorts of worries about aren't we in some sense loading the dice or begging the question or something like that, or doing something circular by having a decision-making procedure that we use to make decisions about decision-making procedures, which we then use to make decisions about matters of substance rather than how to use decision-making procedures. Waldron says, look, in practice, these things are messy and they come as a package. And you can't neatly and ideally tease them out and, okay, here are our concerns and theories about decision-making procedures, here's our worries about matters of substance, we'll settle these worries, figure out the right procedure to use for everything, and then apply it over here, right? No, there's always give and take. These things intersect with each other. If you've got a certain view on a matter of substance, you're going to favor a certain sort of procedure, or at least some people will. All right, others might tease those apart. But in practice, it's all messy. It's interconnected, right? It comes as a kind of package. This is sort of a lovely segue. So one thing I will note, I think Waldron's piece is wonderfully organized, because just as I'm talking about it here, and this, as I read it, it all made sense, but as I'm talking about it, I feel even better about it. It's a perfect segue into this section here about the messiness of real democracy and having to make decisions and make decisions on decision-making procedures by using decision-making procedures. Democracy, like all forms of political and legal organization, is not perfect. Now, a Bill of Rights, some kind of written constitutional document outlining rights, may allow for revision or not. Right? There's really two possibilities here. So you can have a Bill of Rights that itself is static, that so long as that legal system continues to exist, itself is just the way it is. So look, in Canada, say, with the adoption of the repatriation of the Constitution and the adoption of the Charter of Rights and Freedoms, it could have been, right, you could have put right in the document, something along the lines of, here are the fundamental rights of all Canadians, these will never change, and there's no process by which these rights can be altered, amended, added, or subtracted. Right? This is it. As long as Canada exists, here's the basis of the system. And really, constitutional documents are trying to do that. They're establishing what the framework of all the rest of it is. What's the bedrock on which the rest of the structure, which might come and go, can be built on? So you can have a bill that's of something like a Bill of Rights or a constitution that's enshrining certain rights that's static that way, says this is just how it is and that's it, or it can allow for revision. Now in practice, nope, it was a little quick. If the system doesn't allow for revision, then those rights are permanent. Now in practice, that's in some sense unusual, not in a Gallup poll sense of a majority of democracies don't do it this way. I'd have to go study more democracies to know that. That sounds like a weird thing to say, but it's exactly the sort of thing a political scientist does. They go and study different sorts of political systems and how they actually function. Right? Now, if we think about Canada, United States, some large democracies like that have some sort of written Bill of Rights or something similar to it, they in fact do allow for revision. Right? And Waldron himself unequivocally says, if it's going to be, you're going to have something like this, it should allow for revision over time, right? To not allow for revision is just wholly undemocratic. It says, here are the rights, and I don't care what the rest of you think. There's nothing you can do to change these. Right? And of course, depending on when that Bill of Rights gets written, what you're effectively doing if you don't allow for revision is enshrining a certain kind of thinking by a majority of people in a certain time to then dictate all future rights. So look, if you allowed some Bill of Rights from, I don't know, mid-19th century, might have right in there all sorts of rights for men, but not for women and children, right? Might even be racialized. Well, people from this racial group have all these rights, and people from that racial group don't. And if you don't allow for any kind of revision, then you're just stuck with that. I don't think we'd like that, right? And thinking now into the future, of course, we may think, well, we got it right. Of course, they were wrong and silly, but we really have it right. Well, then you're just thinking like everybody who's probably ever existed has usually thought. So of course, we could come up with some other set of rights and we think they're perfectly fine. Give it a couple hundred years and people might look back and be like, wow, they were really in the Stone Age about some of these things. So assuming we allow for revision, which Waldron thinks unequivocally we should, right? If you're going to have some sort of written version like this. Well, even allowing for revision, as long as you have rights entrenched in a constitutional level like this, you are making it harder to revise those rights than you are to revise other rights that are created by ordinary legislation. So you are still putting restrictions on the democratic process. You're making it harder for, say, people in the future or exactly however that's going to work. Well, I guess it's always going to happen to people in the future. Make it harder for people in the future to change their minds on something and to alter how they themselves are governing themselves than it was for you to come up with something in the first place. This sort of thinking, Waldron thinks, is really motivated by those characteristics he was talking about in section 4, namely kind of self-assurance that you got it right, and a distrust that other people are going to be able to get it right as well, right? A sort of distrust that they're probably going to screw it up, so you need to safeguard them against themselves. Now, so there's a worry there, just in the second point, that making it harder to revise certain rights by making them constitutional, there's something undemocratic about that, precisely because you were trying to take away a certain kind of decision-making power from future members of a democracy. Now, even if you have some kind of written Bill of Rights, some kind of constitution that entrenches certain rights, and make it harder through the normal legislative process for people to, say, vote, have the representatives change what those rights are and how they work in practice. As a matter of fact, courts are going to change what those rights mean in practice, how they actually function, by offering new, right, novel, authoritative interpretations of what those rights really are. So he cites, for instance, he just says, look at the United States. The United States Supreme Court offers new interpretations of what the Constitution means. Now, the United States Supreme Court is not empowered to change the written text of the Constitution. They can't come along and say, oh, yeah, we really prefer it if the Second Amendment read this other way, right, than how it currently reads. They're not allowed to do that, but what they are allowed to do is offer new interpretations of exactly what that document means and what the wording means. Now, of course, we can think about Dworkin and the kinds of restrictions that there are on interpretations. But ultimately, there's some decision-making procedure in place. There's disagreement on various levels about what the Constitution really means. This works its way up, and the ultimate decision-making procedure is that the justices in the Supreme Court hear the arguments, they hear the reasons, they think through them, and they come up with some kind of decision that they support their own reasons. Now, it's just not always the case that those reasons are ultimately persuasive to all people. And he points to the Roe versus Wade decision. Now, and of course, this is the big decision by the United States Supreme Court that made access to abortion a legal right. Now, something that's pretty interesting, and he just sort of hints at it here, and I'm just going to say a little bit more, but leave it up to you to go do a little bit of research if you're interested in it. So in that decision by the United States Supreme Court, there's two interesting features about it. Well, okay, at least two interesting features. One, the grounds on which they decided there was a constitutional right to accessing abortion was actually based on a woman's right to privacy. Now, if you actually look through the United States Constitution, so far as I know, the word private or privacy never appears except in the context of talking about private property. But the justices in the majority opinion decided that there was such a right to privacy guaranteed by certain parts of the Constitution, which they themselves didn't even specify. They pointed to a couple of different places where you could derive this right to privacy, use the derived right of privacy to then justify access to abortion, ultimately by way of saying, something like women have a right to privacy in terms of medical treatments and so on. So, right, very, very interesting. There you've got an interpretation of what the Constitution really means that itself isn't rewriting the Constitution, but is offering a fairly novel way of interpreting and understanding what the words that are written in there actually mean. Now, I said that there's two interesting parts of the Roe versus Wade decision. So the first one was precisely this, right to privacy that's used to justify access to abortion. The second one is that right in the decision, the justices admit that there are these other considerations that factor into whether or not states allow abortions and up to what point. So they admitted that really what's going on here is that there's reasons on either side. Should we allow abortions or not? And they said, well, the right to privacy guarantees that women need to be able to access that sort of one way or another. But there's going to come a point during pregnancy when states can justifiably say they're not allowed to do it anymore. And then they sort of left it open about exactly when that's going to be. Where's the tipping point, right? This is part of what's going on these days with states passing, in some sense, obviously unconstitutional abortion bills. Why are they unconstitutional? Well, because they violate the Roe versus Wade decision. But what's going on is that states who are trying to restrict access to abortions are trying to get those bills through and get them before the Supreme Court in the hopes that changing who's on the Supreme Court will ultimately present an opportunity for Roe versus Wade to be overturned, precisely because justices looking at the case might then look back at the previous decision and precedent and so on. They might either distinguish between what they're deciding now and say, we're not overturning Roe versus Wade, but in effect, we're going to nullify it. Or they might just come out and say, yeah, that case was decided wrongly, and here's a new precedent to set. Because, of course, when you're the highest court in the land, you can do that sort of thing. And this ties back into what we were just talking about with Waldron here, about debates between procedure and matters of substance. So look, if you are somebody who wants to see abortion sort of outlawed or restricted, all right, somehow see Roe versus Wade overturned in the United States, how do you go about that? Well, one way is to argue for a radically new procedure, right? Okay, let's not use the United States Supreme Court anymore. Whoa, that's pretty radical, right? That you have to all of a sudden reorganize the way that whole legal system functions. That's really hard. That's very difficult. A different, less difficult, but still difficult way of trying to get your way on the matter of substance is by looking at the procedure, right? The procedure being when the case goes before the United States Supreme Court, if they're willing to hear it, those justices are ultimately going to be the ones who decide what the law is, what the Constitution really means, and what the rights are, and so on. So if you can figure out ahead of time who would make a good set of justices who would form a majority to overturn Roe versus Wade, and then you elect in the right sorts of people in terms of representatives, senators, the executive branch, say president and so on, who are actually going to get the judges you need in the right places so you can use the procedure that's already there and agreed upon to get the result you want. Well, that's a way of manipulating the procedure, not in the sense of changing it and distorting how it works just on a procedural level, but by using that procedure and manipulating it to get the sort of result you want. Effectively, this is what's happening in the United States right now. Now, as I'm saying this, of course, even with the language I'm using there, manipulation and so on might sound like it's very loaded and, oh, look at this terrible thing they're doing. No, I'm just trying to point at facts. So when I'm using the word manipulate, I don't really mean it in a loaded pejorative sense that this is something bad. I mean it just in the sense of when you are using an instrument trying to get a certain kind of result, so you have an instrument or procedure, right? You manipulate it to get the thing you want. I manipulate my computer to record this video, to have the slideshow up, to have me up in the corner on the camera and everything. I manipulated it to achieve this result. There's certain procedures I use, the mouse and keyboard, plugging things in, et cetera, et cetera, et cetera, right? So I manipulate the procedures to get the result I want. And we all do this all the time. And this is precisely where these issues run together. Separating out procedure from matters of substance in practice is really hard to do. And any debate about one of those things is probably going to involve the other one too. So coming back, just sort of looking at Waldron here, what's up on the screen right now. So even if there are written constitutional rights, just looking at the bottom point, right? And we limit the ability of people in a democracy to change what those rights are by making it harder to change them than it is to change normal pieces of legislation. Courts are still going to be able to change those rights, what the rights are in practice, by changing what those written documents mean. So what this is opening is the door to judicial review, which, as we outlined in the first part of this series on Waldron, judicial review is really the practice of judges reviewing and potentially striking down or altering legislation produced by a legislature based on whether or not that legislation is compatible with written constitutional rights or not. And given that judges become the arbiters of what those constitutional rights really are in practice, based on what's written down and how they interpret it and so on, then what you get is a less democratic way of revising rights than you have if you just allow the legislature to directly revise those rights, because the legislature is directly responsive to the citizenry, right? If the legislature goes ahead and changes rights in a way that the majority of the citizens in a democracy don't like, next election, they're going to vote out those people. They're going to vote in new people. The new people are going to go change what the rights are, right? And make it express the will of the majority. This is the basic idea here that Waldron is presenting. Now, there are, well, I got to move myself again, 3 objections and responses to Waldron's view, the view we just heard, that allowing for judicial review is less democratic than just letting the legislature decide it directly. So first, and I've got to change, here we go, I'll shrink myself down. First, the judicial power of interpretation and revision is simply unavoidable. That is, even if you want the legislature directly passing pieces of legislation which determine what our rights are, you're always going to have judges being involved in interpreting, revising, and applying those pieces of legislation in practice. Right? Waldron responds, this is an objection to Waldron's view, right? That judicial review is less democratic than the legislature. And so we just shouldn't have written constitutional rights. Instead, we should just allow legislatures to pass pieces of legislation, so in effect make law, which then determines what our rights are, with no particular rights being outside the scope of the legislature to revise, right, based on their agreed upon decision-making procedures, whatever those are. So Waldron's response to this first objection. Look, it might be true that judicial power is always going to be involved in interpreting, revising, and applying rights, right, in terms of what's going on in the law. But as he says, it just doesn't settle the issue of whether other institutions should not also have the power to revise the official understanding of rights. He says, sure, judges are always going to be involved and they're always going to play this very important role in the process. Sure, I'll just admit that. Yes, you're right. But the fact that judges are always going to have this role to play itself doesn't tell us, or doesn't really give us an answer to this question whether or not other institutions such as the legislature should have the power of revising this understanding of rights. Shouldn't the legislature be allowed to pass, revisions, amendments, certain acts of interpretation, which then help revise what rights are in practice in ways that might, in some sense, complement the judiciary? Right? Just because the judiciary is going to be involved unavoidably doesn't tell us that nobody else, such as the legislature or the people in general, should be involved either. Or that, and we're going to see this really in another objection, or that the judge's power to make these revisions should be superior to that of the power of the majority of the people to be able to do that through their representatives in the legislature. So if we are allowing rights to be amended, whether it's rights in general or these entrenched constitutional rights, which really Waldron is arguing against having them entrenched that way, it's simply less democratic to allow only judges to make those revisions and amendments than it is to allow the legislature to do it as well. And of course, there's this point here that I've just stuck in parentheses, to allow only judges to more easily do that. What do I mean there? Well, again, if you entrench the rights in a constitution, part of the feature of having a constitution is precisely that it's harder to change what's in the constitution than it is to change normal pieces of legislation. This is really the key feature of having a constitution, that sort of foundational bedrock thing, and everything else is built up on it. You can switch out all the pieces on top, but the bedrock, the foundation is much harder to do anything with. And you need some kind of supermajority, right? You need some sort of special over-the-top agreement to change the foundation, to change the Constitution. So by entrenching rights in a Constitution, you make it extra hard for the people in a democracy to change them. But judges do that more easily because from the bench, they don't have to go get a big majority of people. You might have to have a majority on a Supreme Court or something, but from the bench, you can have a very small group of people ultimately decide to reinterpret what certain rights mean and how they function in practice. So effectively change what people's rights really are in a way that's much easier than, you know, the typical ordinary members of that society, what they are able to do in terms of changing what those rights are. They have a much harder time doing it. Not only do they have to convince a majority of their fellow citizens to vote in the same kind of way, they have to get some kind of supermajority. It's not even just the normal threshold for changing our rights and how things work. You have to do this like extra important thing. Judges seem to have a much easier time. Right? There's a lower bar they need to meet to be able to do it. Second objection. Judicial review, this practice of judges looking over legislation, striking it down, making sure that new pieces of legislation cohere with our Constitution, and so on. Judicial review really is democratic. Why? Because courts in a democracy are responsive to public attitudes. So there's no real worry here that it's judges doing it, so there's a threat to democracy. Waldron's response. Even if courts are responsive to public attitudes, they're less responsive to those attitudes than legislatures are. As he puts it, both in theory and in political practice, the legislature is thought of as the main embodiment of popular government. Right? The judiciary, while it plays an important role in it, and in a democracy should represent the prevailing public attitudes, the will of the people, so to speak, it does so in a way that is just less responsive than legislatures do. Right? Legislatures, there are frequent-ish elections, there's turnover in who's in there, it reflects public opinion, at least at a certain time, right, based on whatever the election day was. Public opinion on that day and how it motivated people to vote one way or another then determines the course of action for the next while. You just don't get that same kind of responsiveness in judiciary, or at least not necessarily, at least not in any judiciary where judges are appointed by even democratically represented individuals. Because depending on what the arrangements are like, you might have a judicial appointee serving for years or even decades, right? And so public attitudes from decades ago might still be influencing what rights are today, but it's even, in some sense, less democratic than that because it's public opinion from decades ago determined who the representatives of the people were, who then selected judges who over the intervening years may have changed their minds considerably. And this is something that does happen. A judge gets appointed by someone, and they're appointed because the democratically elected representative thinks that they're going to vote a certain way and act a certain sort of way. They get appointed to something, say, the United States Supreme Court. It's just sort of an easy example to work with. I should stick with the Canadian context more. I'm sorry. So you get this sort of thing in Canada as well. You appoint a judge for, say, a lifetime appointment or a 10-year appointment or whatever it is. They get on the bench and suddenly they're a very different person. You thought that they were going to be, I don't know, very, very liberal, right? Very progressive in their decisions. And they get on the bench and all of a sudden they're screaming conservative, right? Well, that's not what I expected, right? It's not like you can get a refund. You don't go and, well, I didn't want you to do that, right? Yeah, but they're judges. They're not politicians. There is a kind of separation there, though it's not an impermeable boundary, right? There is crossover between the two spheres, certainly. If there wasn't, there'd be a real question about how democratic the judiciary is at all. But there is some degree of judicial independence, which is precisely what makes the judiciary less responsive to public attitudes. That can be a good thing, right? It can also be a bad thing, depending on how we want to look at it, how we think, how we answer a number of other related questions. So the main point that Waldron's making here is really to have the judiciary striking down acts of the legislature as unconstitutional is less democratic than making the legislature supreme over the judiciary in determining rights. Because the judiciary is less responsive to public attitudes, even if the judiciary is democratic to some extent, it's less democratic than the legislature itself. So to have a less democratic body strike down acts of a more democratic body itself is threatening to democracy, or at least results in less democracy rather than more. Third objection. Actual democratic practices are imperfect, right, as we've already talked about. So they shouldn't be trusted to settle such important issues such as what our rights really are. Waldron's response. Democratic practices really are imperfect, he agrees. But that's not an argument to exclude people from participating in them, right? Not letting certain people vote, for instance. We already talked about just taking a quick look at history, looking at the history of the franchise, right? Who gets a vote, right? Is it only adults? Should older people get to vote, right? Now we have increasing knowledge about issues with dementia and so on. Is there a certain age at which we should stop letting people vote? Is there a certain mental capacity people have to vote? Should we have an IQ test or something? Right? These are real proposals. Now, of course, there are real dangers there, and it can be really hard to marshal enough support for, having an IQ test or something. Even if we introduced a sort of test, right, about who gets to vote, you have to pass the test first. What's on the test? How is it going to be written? Who evaluates whether or not you pass the test? How issues of procedure and substance come together. So look, even if democratic practices are imperfect, which they are, Waldron says that's really not an argument to exclude people from participating in them, and it's also not an argument in favor of letting the judiciary settle matters of rights. Letting the people participate in debates about rights is more democratic than letting the judiciary decide such cases. This is an issue of less or more, not an issue of perfect versus imperfect. Just because participatory democracy is imperfect doesn't mean we should seek some sort of alternative system to settle important questions. What that really means is we should work to make it a better system. Right? And the fact remains that even while it's imperfect, it's a more democratic approach to let the legislature decide issues of rights directly, given that they are directly responsible to the voting public, than it is to let the judiciary decide those important matters. Right? So really, legislature should be supreme and the judiciary should sort of serve under it. Once you allow for judicial review, you start flipping that around and you have the legislature passing pieces of legislation trying to revise rights and so on. But as long as you have rights entrenched on the constitutional level, ultimately it's up to the legislature to, in some sense, pass legislation, and then the court, right, the judiciary, however it's set up, ultimately gets the final stamp of approval. And they say, oh yeah, that legislation passes the test, that's fine, you can do that, right? Or the legislature might pass, but according to all the right procedures, some new piece of legislation that introduces a new right or changes how a different right works in light of who knows what, right? Some emergent circumstance or something. New ways that people look at things, new sentiments, right? Perhaps progressive, perhaps not. And then you have the court saying, oh no, you can't do that. I know 70% of the people in the country would actually like things to be this way, but that's not what the Constitution says. And who's to say it's not what it says? We are, because we get to interpret what it means. Right? So no, we're going to strike it down, or you have to go revise it or do something else. I know that's the will of the people, but I don't really care. Right? Or, maybe it's more than one person, probably is. So what? It's going to be 3 people or 5 or 7 or 9, or maybe it's 15, right? Maybe 21, any odd number of people. So they're not going to get locked, right? And you get precisely this thing when you have some sort of Supreme Court or High Court or Constitutional Court invested with this kind of power, that 7 or 9 or however many people, those judges, based on a majority vote, right, will get to override the, in fact, democratic will of millions of people. That's really what this amounts to in practice, and that's the way Waldron wants to put it as well. He says, really, the best way for us to think about these things is in the individual case. And this is really what he does in the conclusion, but just before we get there, there's one last question, right? So even if Waldron's been right all this time, it's better to have the people directly determining what rights are through the legislature than it is letting the judiciary decide these things. Wouldn't it be undemocratic to prevent the people from instituting some kind of Bill of Rights or set of rights in a written constitution, right? And he actually brings this up in that British case. He says, look, in the UK, it's actually, the public opinion seemed to be largely in favor of introducing these written rights. So wouldn't it be undemocratic to prevent it, if that's the will of the people? Well, look, there's a kind of analogy here to be drawn to a pre-commitment strategy, right? If you think of an individual person and you think about the decisions that they make, you can have a kind of pre-commitment strategy where ahead of time you commit to a certain kind of decision which you then don't let yourself later revise. So look, you know, it could be gambling or drinking or, you know, anything like that where you think in the moment people might be weak in some sense and not be able to correctly control themselves, right? Make the decision they really want to make. So something like this, you know, okay, I'm going to go to the casino and I'm only going to gamble with $200 today, right? No matter how much of a streak I seem to be on, no matter how good I feel about my odds, no matter what it is, I'm only going to have $200. Once that's gone, that's it, no more, right? And in fact, you can pre-commit yourself that way. You can, you know, leave all your ATM cards at home. You only have $200 in cash or something. You make it almost impossible to get more money. So this is just the idea, pre-commitment strategy. And it seems like having something like a written Bill of Rights allows for exactly this kind of thing. A democratic community pre-commits themselves and say, okay, I know in the future we might, in the heat of the moment, we might make some bad decisions. So ahead of time, we want to make sure we're committed to all these things and then make it really hard in the future for us to change our mind. But there's a disanalogy, right? A very important disanalogy. There's a relevant difference between the pre-commitment strategy being used by an individual person and the pre-commitment strategy being conceived as what's happening when a democratic community agrees to have a written set of rights. When it's the individual, there's an interesting question there about whether or not it's the same individual through time, right? Of course, for it to really be a pre-commitment strategy, it really has to be. If I say I will only gamble with $200 today, and then later in the day, you know, I wish I had more than $200, but I'm already pre-committed. I know I can't have more than that, right? Because I earlier today decided that I wouldn't do anything more, even though now I really feel like it. But the decision's already been made by me. Now, of course, if I'm not the same person through time, the fact that earlier in the day somebody very similar to me, who you would be very tempted to call me, decided that I should only gamble $200, doesn't really give me now good reason to only gamble $200, because if I'm not the same person I was as this morning, then it's not me who now exists who made the commitment. Right? Effectively, what's going on is some other person, you know, someone who used to be very much like me, but who now doesn't exist, made this decision, which now influences me. That's really a kind of tyranny, right? Just be like if you decided I should only gamble $200 today, but it wasn't my own decision, right? Then it's not me making a pre-commitment, it's you telling me something or letting me do something. Same thing when we go to the society. You might think of a democratic society as this one thing persisting through time, which in some sense it is, of course, but there are always disagreements within society. It's just not the case that within a democratic society or any other sort of society, everybody actually thinks the same thing. There's widespread and persistent disagreement. So that makes there be a disanalogy between the individual case, right? Some person, say like me, saying, I'm only going to do this later today. I'm only going to gamble $200, right? Well, presumably when I make that decision, I'm sort of unified in my commitment. Right? At that point, it's like, okay, I've made a decision. I've weighed everything. I've thought about it. I've now made the decision. When we're looking at a democratic society or just a society in general, there's always this ongoing disagreement, right? So there's always this back and forth, this give or take. So if we enshrine certain rights in some sort of constitutional document now, we are really favoring, we're privileging the sentiments of the majority today over the sentiments of the majority tomorrow or next year or the decade after that or whenever it might be, right? Whenever people come along and as a majority within a democracy say, we think we ought to revise how these rights work in such and such a way. And their representatives go through the legislature, agree, pass legislation to that effect. When you enshrine and entrench certain rights within some kind of constitutional document, really what you're saying is the sentiments, right, the judgments and feelings and so on of the majority, whenever that document is created, are now worth more. They're weighted more heavily than the majority judgments and sentiments at some future time. Because now these people have to have even more agreement to change what's going on than there might have been in the initial case where the rights were being entrenched to start with. So the last point here is really that people can use democratic procedures to weaken democracy. So even if people now want, even so overwhelmingly, want some sort of written constitutional document with rights entrenched in it, that itself might weaken democracy. And this just feeds back into the earlier point we're making, that a democratic decision-making procedure can actually pose a threat to democracy. But Waldron says that's just always the case. Right? We're always stuck with that problem. So it's not some sort of special problem that is an overriding concern that makes us say, oh, so we must have some sort of bill that at least enshrines, say, participatory rights or something like that. Okay, now there's no section 12, right? It's just omitted by the editors. So around to the conclusion, really last points here, which is good because I've been actually trying to time myself and I see I'm just a little bit over time. So trying to make this quick. In closing, Waldron makes this final point, which is one that I think I've already raised, but I'll raise it clearly here. There is a certain kind of harm, a sort of procedural harm done by the very act of excluding people from making important decisions. So I think this is a really interesting point he makes in this last section. He says, if a process is democratic and comes up with the correct result, it does no injustice to anyone. Right? So if you have a democratic process, and we're just assuming a democratic process is a legitimate one, respects people's right to participate in the political process and so on. So you've got, right, and we were thinking about this earlier. We're thinking about this last video and this video. We need some kind of decision-making procedure, right? Some sort of process to actually decide when we disagree. And assuming that there are right answers. What situations can we have, right? Well, you can have use the right process, democratic process, get the right result. You can use an undemocratic process. What am I going to do? So thumbs up, I guess. Democratic process, right result. Wrong process, right result. Wrong process, wrong result. Right process, wrong result. Right? Those are really our 4 options, right? Now, if a democratic process comes up with the right result, it does no injustice to anyone. Everything's great. Well, so the thumbs up works, right? But if the process is not democratic, it's non-democratic, it's a bad process, it inherently and necessarily does an injustice in its operation to the participatory aspirations of the ordinary citizen, right? And it does this injustice, tyrannizes in this way, whether it comes up with the correct result or not. Right? So it doesn't really matter what the outcome is. If the procedure isn't just to start with, there's always a certain kind of procedural harm that gets done. There's a certain sort of tyranny or injustice. There's a certain sort of moral right to participation that's being violated by not having the right kind of process. Using judicial review, arguably, is precisely that kind of process. It's not democratic, or at least it's less democratic than the process of having the legislature decide these issues directly. Now, even if the legislature, so let's assume letting the legislature decide is the right process, it's the most democratic one. So it would be the right procedure to use, in Waldron's view. Now, what if it comes up with the wrong result? Well, obviously that's an unfortunate situation. We'd rather have the right result through the right process. But we can never know with certainty, certainly not ahead of time, whether or not we're getting the result correct, right? We can, arguably, know better whether or not the process is correct. Though, of course, there's going to be arguments about the process as well. Assuming that the process is democratic at least speaks in its favor, right? So unless we have good overriding reason to believe that some other less democratic process itself would actually be a better process, we've got at least prima facie reason to favor the more democratic process over the less democratic one. There's, of course, that question of what sorts of consequences are going to result, right? Is the more democratic process, the better process, less likely to produce correct results? Maybe, maybe not. That's an interesting situation. What we have here is a bit of a parallel to moral philosophy between, you know, something like Kantian deontology and utilitarian consequentialism. Questions about process, about how things get done and what the results are. Which should we privilege when it seems like those two things come apart? Of course, we want thumbs up all the way. We want the right process, the right acts, and the right results. If only the world were so neat. But if we have to have a trade-off, what do we trade off? Do we keep the right process, the right sorts of acts, act according to duty if you're caught, even if the outcome isn't desirable? Or do we flip that around and like, no, look, even if you have to do something sort of underhanded and we might think isn't the great thing to do all the time, if it gets a really good result, sometimes that's just the right thing to do. This really is the point that Waldron's leaving off on. So just to sum it up, and I'll stop spinning my wheels here. I could probably keep talking for another hour, but I'll try to stop somewhat on time here. This final point is really this, that look, by opting for written rights in a constitutional document and having judicial review, you're opting for a less democratic process, and at least on the face of it, there's a certain kind of harm that comes from having a less democratic process than a more democratic one. There's still this question about what the results are going to be, but it seems like at least at this point, Waldron's saying, the burden of proof is on somebody to show that a less democratic process would actually be more favorable to the more democratic process, given that the less democratic process or non-democratic process causes a certain kind of harm just on its own. Can we, in some sense, offset that harm sufficiently through some other kind of process, presumably based on the results it produces, that would make that alternative process of, say, judicial review the better one to use? Well, Waldron certainly doesn't think so. And next week, we're going to take a look at Will Wallachau, who's at McMaster University in Ontario. And he is going to argue for really precisely that case, that in fact, opting for something like judicial review really is the right way to go about these things, that it's not, like Waldron says, always the best idea to have the legislature directly deciding on these sorts of issues concerning basic rights and so on. So thank you very much for your attention. I hope you're all doing very well, and I'll see you next week when we get into our final piece of the course. Bye for now.